Thank you everyone for being here. My name is Craig Damian Smith. I'm one of the senior research associates here at the CERC Migration and Integration at Ryerson. I'm joined by the co-authors on this report, Sean Rehag. Sean's the director of the Center for Refugee Studies and the founding director of the new Refugee Law Laboratory at York, as well as an associate professor at Osgoode Hall. Trevor Farrow, also a professor at Osgoode Hall, and the chair of the CFCJ, the Canadian Forum on Civil Justice. And our discussant and moderator today is Professor Sherry Aiken. Sherry's an associate professor and the academic director, graduate diploma in immigration and citizenship law at the Faculty of Law at Queen's University. Before we start, I want to do a brief land acknowledgement. The land that this university sits on in Toronto are part of the Dish with One Spoon territory. And the Dish with One Spoon is a treaty between the Anishinaabe, Mississauga, and Haudenosaunee indigenous peoples of this land, which was signed in the mid-18th century in the wake of colonial wars between France and England, and the treaty bound them to share the territory and protect the land. Subsequent indigenous nations and peoples, Europeans, and all newcomers have been invited to the treaty in a spirit of peace, friendship, and respect. And I think personally, it's particularly important to recognize the very live impacts of these historical legacies, given that the university where I work is named after Egerton Ryerson, who was an architect of the Canadian state's residential school system, which was part of a project to erase the culture and society of the land's indigenous peoples, and one which the university is responding to now through a process of renaming the institution. So I'll start with the substantive portion of this now. This is a report that was put together in collaboration, and the event is being hosted in collaboration with the Center for Refugee Studies and the Canadian Forum on Civil Justice. It was funded by the Social Science and Humanities Research Council, as well as UNHCR Canada. The title is Access to Justice for Refugees, How Legal Aid and Quality of Counsel Impact Fairness and Efficiency in Canada's Asylum System. Just as a bit of housekeeping, I'm going to briefly run over the main points of the report. Everyone who signed up here should have received the report yesterday afternoon. And Cynthia, I'm not sure if you can put a link to it in the chat there in case anyone hasn't seen it. And then Sherry will provide some commentary and responses to the report. And then we're going to leave as much time as possible, hopefully 20 to 30 minutes, for questions from everyone who took the time to join us today. 1 second. I'm just going to share. There we go. I get a thumbs up from one of my co-panelists if you. All right, fantastic. So as this slide suggests, this is the title of the report. Before we start, I just want to give some thanks to UNHCR Canada, to the Immigration and Refugee Board, the legal aid plans across Canada, and all the shelters and civil society organizations, and particularly the people who are refugee claimants who took the time to talk to us to put this together. It's a pretty rich report, so we're not going to get to talk about everything now. I'd invite everybody to read it, and obviously people can feel free to be in touch afterwards. Just to walk through the rationale for the report. So this report came out of a number of very live issues. The first and most obvious one was federal and provincial funding for immigration and legal aid, in particular in 2019, when the government of Ontario announced cuts to funding for legal aid in Ontario, which is the province which receives the highest number of refugee claimants. But also it goes back to a much longer standing issue, which is stagnant overall funding for refugee legal aid, and as some analysis has argued, actually a decrease in funding when measured against inflation. Those funding cuts in 2019 came at the height of a very large increase in refugee claims in Canada, specifically Ontario, and just before the federal election. And you know, I'll talk about this in a moment, but basically annual asylum claims in Canada at that point had doubled year on year over 2016. The other major driver for this was accounts from previous research projects that we'd undertaken from refugee claimants, which I found quite surprising, being an international relations scholar, but those essentially were very consistent accounts of refugee claimants who were in vulnerable positions, experiencing either low quality or abusive counsel. And then finally, the observation that in response to the very large uptick in asylum claims from 2016 to 2020, the federal government had devoted a significant amount of funding to the Immigration and Refugee Board to increase capacity, but had not matched that with increased capacity for legal aid across the country. In the report, we provide a very full definition of access to justice for refugee claimants. It's important to note here that this access to justice crisis for claimants is part of a broader crisis in access to justice across Canada. And in effect, the majority of people in Canada have little hope for legal representation. You essentially either have to be very poor at the bottom of the socioeconomic ladder or relatively affluent to get legal representation in Canada. And what the definition notes is that refugee claimants experience their own unique vulnerabilities, which are different but not more than other people who require legal aid. This slide gives a brief representation of that increase in refugee claims in Canada over 2016. As you can see, quite a drastic increase, and this big looming mountain in the back is the IRB backlog. So that's the backlog of cases at the Immigration and Refugee Board. So to do this study, we took what we call the stakeholder approach to collecting data. We ran, which was quite important, we thought, the first ever survey in collaboration with the IRB. So that was delivered to all Immigration and Refugee Board decision makers. That's the tribunal which decides on refugee cases. It went out to 340 people. We have responses from 158 decision makers between the RPD, the Refugee Protection Division, and the RAD, that should be capitalized, the RAD, the Refugee Appeal Division. We also ran 3 focus groups with 6 to 7 people each, with lawyers, staff at civil society organizations and shelters, immigration consultants, and directors from legal aid plans, and conducted interviews with refugee claimants that lasted roughly 60 to 90 minutes. And those were people that we recruited, usually through the help of shelters and organizations who had experienced very specific types of barriers to justice that we were interested in exploring in depth. We also had a lot of support from legal aid plans and from the IRB to get good data on representation, which I think is unique in the way that we presented and the access that we had. I'm just going to walk through some of the key findings in the report. The main point of the findings, I think the big overall thrust is that, and I'll get into this into some charts in a moment, is that the crisis in access to justice in the refugee status determination system in Canada is about funding and is about the availability of counsel, but it's also about the quality of counsel. We found that one of the main things that people who have worked in the system for a long time, claimants themselves, is that early access to counsel and early access to high quality counsel can kind of make or break someone's experience in the refugee status determination system. People who worked at civil society and organizations and shelters noted repeatedly that a false start at the beginning can follow a claimant through their process. We heard a lot from civil society organizations about catching people who, quote, fallen through the cracks, and lawyers, particularly at devoted refugee legal clinics, repeatedly mentioning that they saw their role very often as damage control by helping people who had experienced some type of poor quality counsel. We also found that the structure of legal aid, that the way that legal aid is funded and administered, allows and gives room for politicized funding cuts, as we saw in 2019. And very importantly, and again, I'll get into this with some slides in a moment, that there was very broad agreement among the majority of stakeholders who we spoke to that the quality of counsel is a more significant barrier to justice and has more negative impacts on IRB efficiency than overall representation rates. We also want to note that while the vast majority of lawyers are devoted to their clients and devoted to providing high quality service, a very small number of say low quality or even malignant actors have a very outsized impact on the system in general. This is particularly the case sometimes with high volume practitioners. And we found that those high volume practitioners who have problematic practices are very often incentivized by low tariffs and the relatively low amount of money they get per case. Interestingly, we also found that there was less of an impact from immigration consultants than expected. We also found that while oversight mechanisms, for instance, through law societies formally exist, there was very broad agreement among stakeholders that in practice, those oversight mechanisms and recourse for vulnerable claimants are practically inaccessible. And that's something that we can get into in the discussion as well. We also had a very mixed reaction from members of the legal community, shelters, and civil society organizations, and then private bar lawyers about the importance of devoted refugee legal clinics. Among people who mostly work on the front line, there was agreement that moving away from reliance on the certificate system for private bar lawyers and moving more towards a system where more claims are taken and dealt with by devoted refugee legal clinics would allow for wraparound support and the inclusion of settlement services and higher quality representation. I'll move on. There was also some key points of interest that weren't particularly part of the findings, but are available in the report. One is that given the income cutoffs and the financial eligibility cutoffs in legal aid, the vast majority of claimants at the beginning of their process in preparing their claims and appearing before the Refugee Protection Division have coverage by legal aid, are eligible, but very often they're priced out of coverage by legal aid as they move through the system. We also found that disparities between overall funding, but also the amount of the tariffs per province incentivized and led to what we call interprovincial burden shifting. So basically lowering the bar for service and available representation in one province often led people to move between provinces. Very interestingly, and I'll move to a slide on this in a second, we found that the relationship between representation, whether or not a claimant was represented by counsel or self-represented, that the appeal rates as a metric for efficiency at the Immigration and Refugee Board were opposite than what we thought. It turns out that people who are represented have higher rates of appeal in most years than people who are self-represented. And we repeatedly heard from legal aid plans that because of the insecurity in funding, that they were consistently making crisis decisions in how they were going to deliver legal aid for claimants. I think I'm going a little bit over time here. I just wanted to point out here that, again, contrary to what we had assumed at the beginning, at the outset of the project, this chart represents the regional and national representation rates. If you look at the orange bar, Canada, regardless of whether or not there are drastic variations in the number of claims, as an average across the country, we see relatively high representation, on average around 92% nationally. However, if we look at those figures a little bit differently, and instead of looking at the percentages of representation, but looking at the overall numbers of people who are represented by counsel or self-represented, when we see significant upticks in claims, the number above the bar represents the number of self-represented claimants, we do see a very drastic increase in the number of people who appear at the Immigration and Refugee Board and go through their refugee status determination self-represented. This is what I was discussing about the national appeal rates of finalized claims. I apologize for the potentially overly complex tables here. But what I want to point out here is that until 2019, 2020, and we haven't really dug into and been able to find an explanation for this just yet, but with new system claims, that between represented and unrepresented claimants among most years, there's significantly higher appeal rates by represented claimants. And one of the explanations that we have for that we would put forward is that when an unrepresented claimant or self-represented claimant is rejected at the Refugee Protection Division, that they basically leave the system, that they accept the rejection, and then those who have representation are able to move forward through the procedures for appeal. And this is, I'll end on these couple of things here. So, as I mentioned, we ran the first ever survey with IRB members, and I think it's quite important to show this, even if the tables are a bit complicated. So we asked questions basically mostly using Likert scales, so whether or not respondents agreed or disagreed and to what extent they did, or how common or uncommon, how common or rare specific things were. And what we found was that, yes, it's very much the case, or at least IRB members agree, that without representation, that claimants are much more likely to miss submission deadlines, et cetera, that it will result in longer hearings, that postponements in the hearing process, et cetera. So the kind of binary of represented, unrepresented has significant impacts, according to IRB members' opinions, on efficiency at the IRB. And this is at the same time, between these, I don't know if you can see my cursor moving around the screen, between these two statements, that IRB members were across all regions between the RPD and the RAD were of the opinion that low quality counsel has a far more significant impact on efficiency at the IRB than whether or not claimants are represented. I'm going to finish with the policy recommendations and then stop talking. There are 10 individual policy recommendations. They're quite broad in scope and addressed to individual actors in the system. But the one that I want, and these are the three categories of them, the politicized funding cuts and the mismatch in funding priorities and lack of commensurate support for legal aid, and the outsized impacts of poor quality or abusive counsel point to two kind of big recommendations. One is that the stable legal aid funding, the system requires stable funding that is not just aggregate funding, but is adjustable to demand, that the system requires some kind of early warning systems that allow for funding to be released as the number of claims increase in the country, and that the federal government could provide funding that removes the incentives for politicization and this kind of game of chicken between provinces and territories. At the same time, the federal government could and should step in to fix some of the structural problems. So by giving more funding and flexible funding, but that funding should be dependent on law societies, legal aid plans, and the IRB cooperating to fix the problems with oversight and recourse for problem counsel. And we're firmly of the belief after doing this report that more money without conditions on that funding around quality won't solve the problems that we identify and for barriers to access to justice in the system. So I'm going to stop there. I know Trevor wants to note that this report was a relatively small undertaking, and one of the kind of main outcomes of it is that there is a lot of work that needs to be done looking at empirical data and a lot of different aspects of the access to justice crisis for refugees in Canada. So I'll end there and hand it over to Sherry. Thank you.
Thank you, Craig, and really thank you all three co-authors and contributors to this report. It's an incredibly important report. I'm going to raise what I think are some especially important takeaways from Craig's high-level overview, and raise a couple of questions. And I want to state at the outset that I do so much less from my academic perch at Queen's and much more from my lived experience as a refugee lawyer, which preceded my academic appointment. I spent many years working in the clinic system in Toronto, representing refugee claims, and I also spent a number of years in private practice doing the same thing. So I really have the lived experience of somebody representing claimants in this system to bring to bear on why this report is so important and why we need to ensure that its recommendations receive the traction they so appropriately deserve and end up in action. So first of all, I want to speak about the access to justice piece. This report does an awesome job of surveying access to justice definitions and then essentially pulling those together and providing a definition of access to justice for refugee claimants in the refugee context. And I think that's a very important contribution. I would highlight in particular the emphasis on early and consistent access to publicly available legal counsel. And in doing so, I would differentiate representation, as the report does, from information, right? It's so important to understand that funding for legal information, things like mock refugee hearings, things like here's what you need to know about your refugee procedure, all of those initiatives are important, but they are no substitute for actual representation. In the refugee claim context, 90% of the claim is won or lost on the preparation that's done in advance, both in terms of filing the BOC and compiling, sorting, and prepping the evidence, and ensuring the claimant themselves is prepared for their hearing in relation to their testimony. And all of that work requires legal counsel representation. It's not just a matter of sharing information about what's happening. That's important, but that's not enough. So I think that access to justice definition is really important. The second thing I want to pull out is the important and relatively underutilized role of specialized clinics across the country. There are a couple of provinces that have specialized refugee clinics. They serve as shining examples of the sort of wraparound services that the authors of this report highlight as important, but they're not replicated across the country. And that's a significant finding, I think, and one that deserves follow-up. The issue fundamentally of responsive funding is critical, right? We know that unlike some areas of legal practice, which are relatively stable over time with maybe some blips, like we understand there was a lot more business for family law lawyers during the pandemic as relationships exploded as a result of lockdowns. Relatively speaking, the needs in many areas of law practice are stable and don't require a kind of early warning system in relation to funding available. That's very unlike the asylum context, where we see dramatic surges of need and a funding system that's simply not set up to be responsive. And the downstream impacts in terms of access to justice for claimants is huge. The report does an excellent job of highlighting this problem and recommending the way forward, an early warning system with responsive, stable funding across the country, and why that's frankly the linchpin. If nothing else came from this report, other than action on that one issue, I think there'd be a huge benefit. The final piece I want to tease out in terms of the report's important findings is the need to calibrate financial eligibility, to recalibrate it, right? Because right now we see that it's only the poorest of the poor who are qualifying for legal aid in many contexts. The report doesn't address explicitly the role of financial contribution agreements, although we know those exist, at least in some provinces. But we do know, regardless from the report's findings, that a significant percentage of refugee claimants are not getting access to legal aid. And while those numbers may not be huge relative to the percentage of people who end up represented, they need to be a significant concern, right? Because it's a fundamental failure of access to justice when people are not getting funded counsel. And the eligibility criteria in some legal aid plans are so restrictive. So that comes out, it's very important. A couple of key questions I had in terms of follow-up for future work. It's not so much what this report doesn't say so much as it's a small project and it clearly points in the direction of some additional work needed. So where would that work be? From my perspective, it's a little bit more focused on the role of non-lawyers, paralegals, and immigration consultants. We understand they're a small percentage of the representation pie, but nevertheless, 10% or so. What's going on there in relation to quality of counsel? What are the measures currently underway? And we know there are measures underway with respect to immigration consultants, for example. But shining a light on that piece of the pie, I think, is important. I think as well, we need to consider the role of technology. We know that, for example, hearings at the IRB are increasingly being made available via video conference. There's a lot of concerns about that. At the same time, maybe there's a potential there to cross jurisdictional boundaries in relation to how representation works in this field. Something to consider, the role of technology. The other thing that I think is really important to consider is not just the asylum hearing, not just the procedures before the Refugee Protection Division and the RAD, but rather all the other hearings that refugee claimants end up finding themselves engaged in, whether it's at the front end, admissibility hearings before the Immigration Division, whether it's detention, where non-lawyers actually play, at least anecdotally, I can report a much bigger role and what's going on there. And similarly, what's happening with respect to representation with the pre-removal risk assessment when claimants are deemed ineligible for a hearing before the board? What are the representation gaps there? Those to me are some of the questions, but I'm going to leave it there because I think it's really important to hear from all of you. And I'm actually going to turn right now to the chat and direct some questions to our panelists to address. So first of all, we have a question from the audience directed, I think, to Craig in relation to the findings. Is there an ethno-racial disaggregation of the numbers presented, or second best by country of origin?
So if I understand the question correctly, it's about the outcomes and the rates of representation, et cetera, and outcomes at the RPD disaggregated by country of origin. I mean, that's something that we've been talking about, and we talk about in the findings, is that this type of work requires, we think, a much more long-term research project that builds an aggregated or disaggregated data set that would then allow us to explore all of those correlations. We weren't able to do that with this report, given the nature of the data that we were collecting. We think that it's possible. It just requires more work. Anecdotally, you know, there's some evidence that shows that particular communities are particularly more susceptible to poor quality counsel or abusive counsel. But focusing in on that and making any kind of causal claims on our part wasn't something that we were prepared to do in this report. But people who work in this community, you know, in these communities, for example, part of this research, we did some site visits in Montreal and Park X, and we know that, you know, there are some particularly heinous things going on among with lawyers and communities from Punjab in India. And Sean has also done work previously working with Roma claimants and problem counsel around them. So yeah, there's more work to do there, and there's anecdotal evidence that suggests that certain groups are more vulnerable. I don't know if Sean wants to jump in there.
Yeah, I mean, I think projects that work with specific communities, I think are really important. They're really interesting. They also, though, do raise some challenging, I think, research ethics questions and some challenging political questions. So we need to be very aware, for example, that when there's conversations about abusive counsel, that those conversations can sometimes feed into problematic public discourse about abusive claims. There's often a sliding from abusive counsel to fraudulent claims. Those two things are not the same thing, but they get mixed up in public discourse. There's also some challenges, I think, around the reality of which lawyers are most vulnerable to being found by law societies to have engaged in problematic practices. I think the stakeholders that we consulted with said that these processes are generally not effective, but there's lots of research suggesting that racialized lawyers and lawyers from specific ethno-racial communities are disproportionately targeted for investigations in terms of quality of counsel. And so there's some complexity here in terms of how you approach these questions. Personally, I would think that the answer to that is research that is grounded within those communities, that is not researchers kind of going in and studying the communities, but working with the communities, maybe in partnership with community legal clinics that have good connections to communities. So all that to say, it's a great question, but research in the area is quite complicated.
Thanks, Sean. And in fact, we have a related question about research, and it's from a participant who says, this is a really interesting study on legal aid, and I find the methodology fascinating. Can the authors speak to how they recruited participants? It seems like you obtained a large sample group from many different groups that are often challenging to access. So maybe Craig, that's a question for you.
And the short answer there is relationships with civil society organizations and shelters from previous research, from volunteering, et cetera. There's something that I meant to mention at the outset, and that through this study was the last time that I got to interact with Francisco Rico from FCJ Refugee Center, people who work in this space. And I know a lot of people here were really good friends with Francisco, and that's essentially, it was through people like that who have the trust of people in the communities, and that's how we were able to access people. I mean, the practicalities of that was that we had a great research team as well, and I see some of the people who worked on this project are on the call as well. I see Sean, Zay, and Pamela there. And the practicality of that was that we translated recruitment posters into several different languages and then disseminated those posters through our contacts at shelters and community organizations, and then waited for people to get back to us from a research ethics perspective. That's important that people opt in to this study, and that's how it worked.
Thanks, Craig. Another question about the data around representation. The participant wants to know whether representation includes unpaid representation. So for example, from a family member, a friend, a volunteer, and if so, what percentage are we talking about? So I think that relates to data of represented versus unrepresented.
I guess I can take that one as well. I mean, the represented versus unrepresented data, which also I wonder if Trevor wants to jump in on this too, because I ended up near the end of the study doing like a control F and replacing unrepresented with self-represented because I realized that I wasn't up with the terms of the right terminology or the state-of-the-art terminology. We have the data on types of representation from IRB, who again, their engagement and their stats divisions were great in helping us with this report. So I think I don't have it in front of me, something like 90% of the total are represented by, or high 80% by counsel. Thereafter, it's something like 4%, 5% by immigration consultants, then paralegals, and then other, which means the unpaid folks who are helping out, who are not professionals. So that's the answer on the representation data. The vast majority of people who are represented by counsel. The reason that we didn't put that in, those charts into the report, is because it was not possible because data wasn't collected on the number of those counsel who were paid by a legal aid certificate or lawyers at clinics. So that's another step that needs to be taken if we're going to do research on efficiencies. And with that, I think, Trevor, do you want to talk about metrics around social return on investment and the way that we frame that? Because that's something that was kind of crucial to the report, but I wasn't able to get to it in the overview.
Sure, thanks, Craig. And maybe before I do, and I'll just pause to Sherry as well in case there's other things before we get into that. But just on the self-represented, unrepresented question, which I think is a really important one. Obviously, there's a couple of things to think about. One is stepping back from this report and just thinking about that question generally in Canada, the difference within tribunals versus courts. the difference between the actual numbers and the numbers that we know about, which is really a question about what kind of data we keep and what kind of data we don't keep. And then thinking about what kind of public data we have. And I'm thinking, for example, at courts, some of the data that I'm aware of when they track unrepresented versus represented, it's really about lawyers. So the question earlier was it lawyers or non-lawyers? And so a lot of the data does sort of cut off at lawyers or not lawyers, which doesn't necessarily mean someone has no help at all. But the point I wanted to make is just, it's an area that we need so much more research, particularly as we're exploring the benefits of community workers and other assistants in the context of representation. And different forms of representation. So with that, I'll stop on that point. And Sherry, was there anything that you wanted to jump us back into? Or should
Actually, thank you, Trevor. A slightly different direction. I want to present this question. The report makes some references to comparative examples, particularly between interprovincial dynamics and how differential standards play out between different EU states. So the participant is asking, could the panelists speak more broadly to the differences between Canada and other OECD states in the provision of legal assistance to refugees? They're particularly curious where Canada is in general located relative to broader state practice. So comparative perspective. Obviously beyond the scope of this report in particular, but I think the panel may be able to address at least in part the question.
Sean and Trevor, do you guys want to cover the interprovincial stuff, and then maybe I can talk about the international comparative, because we had a number of in-depth conversations about the relationships between cost per certificate and anecdotal prevalence of bad practices, but I think Sean has thought more deeply about this than I have.
Yeah, I think on the interprovincial question, I mean, there's clearly differences across the provinces. One of the challenging things about this area of law is that it crosses jurisdictional boundaries. So it's, on the one hand, you're in the federal area of law because you're talking about immigration and refugee law. On the other hand, legal aid is generally done through the provinces, and the provinces have adopted very different strategies. Sherry mentioned that some provinces have specialty legal clinics, many do not. Some provinces don't provide any funding for certificates in this area, others do. Some provinces provide broad eligibility for certificates, but very low rates per case. All of these things play out differently in terms of what kinds of positive or problematic practices they encourage. Beyond just those questions, some provinces have tried to grapple with the quality of counsel concern through legal aid programs. Legal Aid Ontario, for example, went through a whole process to try to improve the quality of counsel, both by creating a new process for impanelment, but also by providing very clear indicators of what quality counsel entails, of what they expect when they provide funding. So the practices really vary across the provinces. I do think that one of the messages of this report is that at the moment, it appears that the vast majority of people who make refugee claims do get representation. While that's true, there are some pockets where in the country where people are struggling, and so some consistent funding from the federal government going to all of the provinces would be very important. At the international level, I know a little bit less about this, but the fact that Canada does have legal aid for refugees in most provinces does make us compare positively to a number of jurisdictions. But maybe Craig can say a little bit more about that.
I can say a little bit about it. Between OECD countries, yeah, Canada spends a lot of money on legal aid and support, but also the nature of the Immigration and Refugee Board as an independent tribunal, I think, is the context to consider here. So it's this inquisitorial process. It's supposed to be a non-adversarial process where the members' job is not supposed to be and usually isn't to disprove somebody's claim, but to try to understand the nexus between that person's specific experiences and the definition of a refugee to see whether or not they're eligible, and Canada has a duty to international protection for those people. The system functions as it does, and this is really important because the majority of people are represented by counsel. So that relationship between publicly funded counsel and independent tribunal that renders these decisions under the federal law, the Immigration and Refugee Protection Act, are two sides of the same coin in terms of the way that the system functions in Canada. So international comparative examples are a little bit fraught, and I don't think I'm enough of an expert in comparative asylum systems yet. I will just note briefly that in the EU context, for example, you do often see between states what they call a race to the bottom to make destinations less attractive for asylum seekers, but that's more about where they go rather than what they get from my base of knowledge around comparative asylum systems. But it's also, again, I'll just push this point one more time, civil society organizations, shelters in Canada, excuse me, the public support for refugees, positive public opinion around resettlement and asylum seekers are quite unique to Canada. But the fact that we have this thing that we call the settlement sector, which is a normal part of supporting newcomers in Canada, is unique and important to highlight here. And there is a lot of wraparound support that I would say, as somebody who does work in Europe as well, doesn't exist per se. So that's my long answer to your short question.
Okay, there's a few more things that we haven't got to yet. In the time available, I'm going to kind of cherry pick with apologies in the event that anyone doesn't get their questions addressed. We'll keep the chat, and I'll be encouraging our contributors to continue the conversation. But for now, we have one participant asking, was the report able to capture the actual impact of the $133 million funding cuts for legal aid on the quality of counsel? And relatedly, was the report able to capture specific directions and impacts on LGBTQ plus claimants' access to quality counsel because of the funding cuts and so on? So two related questions.
Maybe I'll jump in on the first part of that, and others can, you can see what you think and make further comments. I think the short answer, could we causally link the quality of counsel to the legal aid cut? I think the short answer is no. I think there's more to it than that. And a couple of things. When we started this report, one of the things we set out to do was actually to look at return on investment. So one of the real goals of this was to look in the context of return on investment literature to try and understand what's the benefit of investing in the system. And the reason that return on investment features in the report, but not prominently, is where the data took us and where the respondents took us. So certainly there's a return on investment literature out there that tends very positively to the connection between investments in legal aid and benefits to those who receive it, and also benefits to society as well. And some of that is featured in the report. For example, when we heard about efficiencies in hearings and what have you, based on quality counsel, you can draw those connections. But as researchers, we couldn't feature that too prominently because the data that we had and the responses that we had didn't take us directly there, which does not mean the absence of a robust return on investment section does not mean that there is a lack of a return on investment. But we can't make that claim in this report. So I think all of our intuitive sense is that the stronger the investment, particularly I think as Craig and Sean and Sherry have noted, coupled with the idea of quality counsel, will yield huge fruits both to the claimants but also to the system generally and to society. And what I would say is it's a massive area for important further conversation because we think the links are there. Data supports it elsewhere. And we want to continue to look at that in this context. But Craig or Sean, do you want to say anything more about that or other parts to Sherry's question?
Maybe I could just say a few words. So part of what makes it methodologically difficult to measure the impacts of the cuts is the mitigation strategies that were used to limit the impact of those cuts, and the fact that the federal government did step in ultimately and provided temporary funding, partly because of the extraordinary efforts of some of the folks that are in this room to persuade the government to do that. And so I think if those cuts would have, if the decision to no longer effectively fund representation at the Immigration and Refugee Board had persisted and the federal government hadn't stepped in to provide some funding, I think we would have been in a position to see really problematic impacts on counsel. I think it's important to keep in mind here that when this report is saying quality of counsel at the moment appears to be a bigger problem than the fact of being represented or unrepresented, it's in a context where the federal government did step up to make that temporary investment that kept the whole system running. We're not saying, oh, it doesn't matter if you have legal representation. We're saying in the short term that gap has been plugged, but there are other problems that need to be addressed in addition to making sure that that gap is plugged in a way that is sustainable and equitable across the country and so on. As far as the question about LGBT, the impact about LGBT groups in particular, our data wasn't disaggregated based on claim type, but I would expect that wherever you have intersecting forms of marginalization and vulnerability, that the impact of problematic counsel is amplified. As someone who does a lot of work on LGBT refugee issues, I know that credibility is really the key issue in a number of these cases. And one of the reasons why quality counsel early in the process, as you're putting together your documents, one of the reasons it matters is because if those documents are not well prepared, it is a recipe for a credibility problem down the road. So our data doesn't look at this question, but I anticipate that if you did pursue a project on this, that you would see that this is a group that would particularly struggle with problematic counsel or the lack of counsel.
Thanks, Sean. I'm going to share a comment question from a family doctor who's trying to run an asylum seeker screening clinic without necessarily the continuity of care. The doctor notes that they often see asylum seekers without access to basic legal information. Information sources are available at borders and airports, they're questioning and noting that they realize now how underfunding makes the legal process more complex. So I guess drawing our attention to the role that legal information plays and noting the inconsistent availability. So I don't know if anybody wants to respond directly to that. It's interesting to have a doctor's perspective on the question.
Yeah, thanks, Dr. Chiglin. I think that one of the big points of this report as well is that this bifurcation between legal supports, settlement supports, civil society organizations, that the lack of information available to claimants, in particular in the findings we discuss in the policy recommendations, the really important role that hearing preparation programs play, that claimants understand their rights vis-a-vis counsel and problem counsel specifically, and mainstreaming those types of supports in a way that intersects directly with the provision of support, of legal support and legal representation. And that's something that across the board among respondents and participants in the study came up, and something that could and should be addressed. One avenue that we recommend for doing that is a specific funding stream that the IRCC has in the Service Delivery Innovation Grants, which is a stable funding stream that could help take best practices and try to mainstream those across Canada.
Okay, I think we have time for possibly one more intervention, and I'm just scrolling through the questions here. We have a comment. I believe it was mentioned that 90% of the success of a claim is dependent on preparation. Given this conclusion, when thinking of quality counsel, did the report find any instances of counsel seeming to have incentive to continue representing clients through the refugee system? For example, to RAD and the federal court. So kind of looking at the scope of representation beyond the board, and certainly beyond the initial RPD hearing.
I guess I don't see any unmuting going on. I don't quite understand the incentive, like a perverse incentive, a negative incentive to keep stringing people along, kind of thing. Is that what's being implied?
Well, it's not clear from the question, but I certainly think the participant is addressing what happens after the RPD. And you talked a bit about the relationship to appeals and the surprising finding in that regard. They just wrote financial incentive, actually.
We didn't find anything like that. I think that if anything, that again, just to reiterate that we found the vast majority of refugee lawyers are in this for the right reasons. We found, I think, that the opposite was true if it has to do with problem counsel, that the incentive is at the beginning to do the least amount of work on people's claims. Very often this was called boilerplate submissions by IRB members, and other stakeholders who we spoke with referred to certificate mills, so like high volume practices. And that's the data that we found that I can speak on with some confidence is around at the earlier stages of the claims process.
Thanks, Craig. I think we're at our hour, and so I'm tossing it back to you to wrap up.
Sean and Trevor, did you have anything to add before we wrap up?
I just wanted to say thanks to all the people who attended for the terrific questions, which we've been noting and animating further questions and comments that we'll be reflecting on. So thanks so much for those, but I'll throw it back to you, Craig, to wrap up.
And I also wanted to say thank you, thanks to Sherry for providing helpful comments and for moderating, but I also wanted to thank the participants in the research project, particularly grateful that the Immigration and Refugee Board engaged with us and provided us with the opportunity to hear from the members. I think it does speak well to about the Immigration and Refugee Board's willingness to engage with stakeholders, willingness to engage with researchers, interest in evidence-based decision-making. I know it can be a bit nerve-wracking sometimes to engage with academic researchers, and I'm grateful that they did that. I'm also grateful that the other stakeholder groups, refugee lawyers, legal aid programs, and refugee claimants themselves engaged with the research project. So thank you, everyone.
I think that does it for us. I couldn't have said it better. Please take a look at the report. It's available on the CERC website, I guess, probably through CFCJ. Sean posted it on the SSRN yesterday. And everybody was here also, I think, received a copy. This is, I hope, more the start of larger research projects and trajectories, and shouldn't be considered as any kind of final word on this. And as I mentioned at the beginning, please do get in touch if you have questions or comments. And if you're a policymaker, please read our policy recommendations.